Well, good morning and good afternoon, depending on where you are in Canada. My name is Tom Engel. I'm going to be moderating this panel, and I'd like to welcome all of you to the latest panel on the series Spotlight on Solitary. I'd like to thank Emily Coyle and the E. Fry Society for organizing this. In this panel, we will discuss the legal actions being taken against CSC as they relate to its response to the COVID-19 pandemic and its obvious relationship to the conditions of confinement, which amount to solitary confinement. Our panelists are both experts in prison law. Their bios are on the promotion for this event, so we only have an hour, so I'm not going to waste any time in reviewing them. They are Paul Champ and Abby Deshman. Because we only have 1 hour, there will be no time for questions, unfortunately, but I don't think that's going to be a deficit. I expect both of them to offer practical tips on how to take on prison authorities when your clients are being harmed by the imposition of solitary confinement conditions and the dangers visited upon them by those conditions, and as well, the failure to properly deal with the risks to COVID-19 vulnerable clients. This should be of use in dealing with the same problems in the jails operated by the provinces and the territories, where the majority of Canada's prisoners are held. Our first panelist to speak will be Paul Champ. He'll discuss the snow and the, is it Jan or Jan?
The Jean case.
Jean cases for about 20 minutes. Then Abby will take over and we'll discuss the action brought by the Canadian Civil Liberties Association and the Canadian Prison Law Association and a couple of other applicants. That's an action brought in the federal court against CSC. And she'll talk for about 20 minutes. Then at the end, I expect to have about 10 minutes where we can have any final thoughts from our panelists. So without further ado, Paul, would you like to begin?
Sure. Am I being heard okay, Abby? All right. So yeah, Tom, I assisted a federal inmate very early in the COVID pandemic. He was a gentleman who was in the Federal Penitentiary Bath Institute in Ontario named Derek Snow. And Derek had a number of health conditions that put him at great risk of a serious outcome from COVID. He not only had pulmonary obstructive disease, he also had cancer, a sarcoma, and thrombosis in his legs, and he was in a wheelchair. Shortly after we began learning about the seriousness of COVID, he immediately began contacting the penitentiary authorities, the warden, asking if it's possible if he could be released or get out of the jail because he was worried he might catch COVID in jail. As some of you may recall, there was all the stories in the early days of the pandemic in Canada of a number of the federal penitentiaries getting COVID running wild in Quebec and in BC. And obviously, many thought that Bath Institute and others would be next. So I got involved with the Queen's Prison Law Clinic, and we tried to put pressure on the Bath Institute to release Derek under one provision of the Corrections in Canada Release Act, Section 116, that allows an unescorted temporary absence. And if you're released on an unescorted temporary absence for medical reasons, the release can be indefinite. And so what we argued was that he was at a serious risk of contracting COVID while in a penitentiary. And further, he was at a very high risk of a severe outcome because of his underlying medical conditions. The warden largely ignored us. We were also contacting the doctor at the institution, who completely ignored us. The parole officer assigned, who also completely ignored us. And so what we then did was we brought an application to court, arguing that the court should compel the institute to make a decision, and in the interim, they should release him, given that his right to life was at risk. And so we put in some expert evidence about not only the nature of his health conditions, but also in particular around transmission of COVID in jails and prisons. Some of us could kind of imagine it anecdotally that, a communicable disease like COVID will transmit more quickly in a facility like a jail. But, obviously the science backs that up, and that there's no places more dangerous than what we call congregate living settings. And so we had an expert that talked about that, referred to many studies, and also said that given his underlying health conditions, he was at a very high risk of death if he was not released. And fortunately for us, the day before our emergency motion was heard, which we got on within about 1 week, the institution backed down. I think they were concerned maybe about a court precedent, and they agreed to release him immediately. So we were fortunate and able to get Derek Snow released. That was about mid-April. And, I think there's other lawyers who've been working on these cases where, people are in penitentiaries in particular who aren't a violent risk. I think that's one of the big things, is if an inmate is not a risk to the public in that way, of violence, and they have underlying medical conditions, or if they're particularly old, like over 60 and especially over 70, these are individuals that the federal penitentiaries absolutely should be releasing. We know that they were very resistant to it in the short term. I've worked on a couple other cases like that since this time, Tom, and what they're doing now is they're channeling them, at least the other cases I worked on when I filed for an unescorted temporary absence under Section 116, they kicked us to the parole board instead and said, look, what you're really looking for is a parole by exception, and we'd prefer to have it treated as parole by exception. Normally, that wasn't a great avenue because the parole board previously would take 6 months to deal with cases. But as the COVID situation became worse, the parole board had undertaken to determine these cases quite quickly. And in a couple of other cases I dealt with, they did deal with those cases quite quickly, and those gentlemen were released as well. So there are some avenues if you have a federal inmate in particular who is not a violent risk, or at least is not a moderate to severe violent risk, and has these underlying health conditions. As many prison lawyers know, Correctional Services Canada, these provisions, Section 116 and Section 121 of the Corrections and Conditional Release Act, they practically never use them. And in the early days of COVID, they were basically ignoring them. They were refusing to process applications, or they were saying they would take months. But I think, the case that we did, and there's a couple other cases, one out in BC, McCullough, and obviously because of the pressure in the media, I think they realized they really needed to address the situation of COVID and the high risk to certain inmates in prisons. So that's that case, Tom. Just by way of, I know that what's arising now in COVID is the problem of increased use of segregation. Unfortunately, a lot of the federal penitentiaries are using segregation as a way to manage the risk of COVID, but then they're running into the problem where they're just essentially leaving prisoners in segregation for prolonged periods. The other case you had mentioned was one that I had dealt with in the provincial jails some years ago. It wasn't a COVID case, but it did have to deal with segregation. And as we now know from many other cases, including the one the CCLA had worked on in the federal system, segregation beyond 15 days can have permanent effects for individuals, can cause permanent psychological damage. And I worked on a case in the Ontario system involving a woman named Christina John. Her case was particularly sad because she was placed in segregation in the Ottawa jail because of her mental illness. As we know all too well, some of these facilities, jails and federal penitentiaries, the default tool for many of them in dealing with or treating or managing inmates with serious mental illness was to place them in segregation, which is particularly horrific because we know that segregation doesn't make someone well. It in fact compounds the harm. And in that case, we were ultimately able to, in the Christina John case, able to get a wide-ranging public interest remedy and settlement with the province that was made public about many measures they were supposed to take to eradicate the use of segregation for individuals in provincial jails with mental illness. That was in 2013. Unfortunately, they haven't been able to meet the mark. We were able to include one important thing was that the province was supposed to collect the data. When we did the Christina John case in 2013, the shocking thing to me is they had no clue. The province of Ontario had no clue how many people were in segregation with mental illness. They didn't track it. They didn't keep data on it. And so as a result of that, of the Christina John case and the public interest remedies, they were required to keep that information on a very granular basis. And, the sad thing is we're seeing that they haven't improved, but we're able to measure it and hold them to account. So there have been 3 separate contravention applications against them, against the province of Ontario and the Human Rights Tribunal. Where there have been further orders condemning them. There have been province-wide reviews of the Jean remedies, as they're called, first by Howard Sapers, who was retained by Ontario, and then more recently, Justice David Cole. So it's, unfortunately, the use of segregation is so deeply entrenched in the culture of corrections in Ontario, and as we know federally as well, that giving up that tool or transitioning or trying to come up with other tools to manage difficult cases is proving so far anyway to be almost impossible for the provincial and the federal authorities. But because of some of these cases that are ongoing, I think we've moved the needle, but we're far long way from solving the issue of the use of segregation in provincial and federal jails, whether it's COVID or whether it's in the sad circumstances when someone who has a serious mental illness and is incarcerated.
I have to do
I think
that
you're both
myself.
muted.
I'm on mute now too.
All right. Just a few follow-up things. Practicalities for people who are watching and listening to this. Okay, so what you're saying is for a federal prisoner, you should try parole by exception.
Yeah.
And what does that involve? What did you do to file those applications, especially the ones that were successful?
Yeah. So what you do is the inmate himself or herself can commence the parole by exception process. They just have to ask the parole officer who they deal with within the institution. They'll file a form. And then what you do as counsel is you follow up with written submissions to the regional parole board office. So, what we did was we had detailed written submissions, obviously dealing with the criteria under Section 121, but we also got medical information about the inmate and their specific medical conditions and why and how they are particularly vulnerable. We cited some of the reports that are out there about the high risk of transmission in jails and penitentiaries, and submitted that. Then what happens is the institution itself, the warden and the parole officer will create a report, an assessment report on whether the individual can be released. Oh, the other thing I was going to say, you want to work on a release plan. So you want to have a decent release plan for the inmate. Hopefully family is available, family or friends. So you have to show that there's a release plan for the individual where they can go. That's hopefully doesn't have any issues with any restrictions they may have or parole conditions. then you'll get to see the report, the assessment report by the parole officer, and then you can make additional submissions on that. The Parole Board of Canada is committed that once they get all those materials in, they'll make a decision within 2 weeks. At least they started making that commitment in early June. I can't speak to others' experiences, but my experience is that they do stick to that commitment. The tricky part is pushing the institution to come up with that assessment report. That's where they will sometimes drag their feet. But if you've got an individual who's a low risk to reoffend violently anyway, and does have a serious medical condition, you should have a decent shot at persuading them to grant that individual parole by exception.
And did you present any evidence? We know, I think, across the country that most prisons say that they are taking the proper COVID-19 precautions, but in fact they aren't. I think we all hear from prisoners all the time that they aren't doing it. Did you present any evidence about the lack of COVID-19 protocol compliance in the jails in which your clients were?
Yeah, a little bit, Tom. You know, I guess different people might take different strategies. When I did the Derek Snow case and we were going to the court, we put a lot of other evidence in, around it. We tried to get very aggressive on that the institution was not doing everything that they could to reduce or mitigate the risk of transmission within the facility. On the parole by exceptions, I have to confess, I kind of low bridged it a bit. I didn't go over the top because at the end of the day, you're trying to convince that warden and that parole officer to do a favorable report. And if you come out swinging and saying they're not doing their jobs, that may decrease the chance that they're going to do a favorable assessment report for you. At least that was my approach. So, you know, I highlighted the things that there's nothing that anyone can do about, like the fact that, you know, in some of these pods or wings of the federal pens, you might have 80 to 100 prisoners and they use 3 phones, right? So that's a natural place where they're going to move, or where they eat. Most often they're eating in a congregate area, and there's just nothing that they, you know, that the jails can or the prisons can do about that. They're not being criticized. And you highlight that the cleaning is generally being done by other inmates. So therefore the quality of the cleaning can vary widely. So you can do things to highlight what are some of the problems in the jail or the prison that is not directly attributable to the warden. At least that was my approach. I guess others might want to get more aggressive on it, but my thought or strategy was not to be as critical as I perhaps could have been about the practices in those particular institutions.
Before you gave that answer, I expected that would be the tactic, and I certainly see the wisdom in that. Now, what about parole in Ontario? Do you deal with the Ontario Parole Board or whatever it's called?
Yeah, in the COVID context, Ontario was actually a bit of a leader on that. You know, within the first month, they had released or ensured that, you know, on unescorted absences, it was about 20% of the prison population in Ontario, or maybe even higher. It might be off on that. It might have been as high as 30%. So they were way ahead of a lot of the provinces in Canada, and they dramatically reduced the numbers. I mean, the other sad thing, obviously, that people in provincial jails, the majority of them are not convicted. So they don't get the access to the, you know, to the unescorted absence mechanism. And instead what they're doing is they're trying to get their release through bail. So I know in Ontario, I haven't looked as closely in other provinces, but in Ontario, we probably have already 40 or 50 reported bail decisions involving COVID, where counsel is relying on COVID to try to secure the release of their client. But I think in Ontario anyway, I haven't heard of the cases where people were trying to get convicted people out on COVID, simply because I think if there wasn't a violent record, the province for the most part was releasing them anyway.
Yeah, I know that is not the case in Alberta. What Alberta does is they'll TA all intermittent servers, but I think it's impossible to get them out on a temporary absence otherwise. So And I don't know what it's like across the country, but there's no similar parole by exception in the Ontario parole legislation, I take it.
No, no, there's not. There's not. But one thing, Tom, when we did again, when we did the Derek Snow case, it was in the federal context, but we did put in the evidence of what Ontario was doing. And I think at that time also, we did have evidence, I think, of Nova Scotia.
Yeah.
Nova Scotia had reduced their prison population. So, if someone in Alberta or one of the other sort of more less enlightened provinces on those issues, shall we say, I think it would be helpful to maybe get evidence of what the other provinces are doing. If you're going to be ultimately before a judge, I think it's helpful to show a judge, hey, all these other provinces are doing it, and guess what? There's not a there's not a crime wave of in those jurisdictions simply because they're letting out some guys who might have substance addiction issues and do some habitual property crimes. There's those people aren't going to cause a violent crime wave, and we're all safer, quite frankly, if you release them. And that was actually another thing I was going to say, Tom, is on those, the evidence also is very clear that the wider community is safer if you reduce the jail populations, because the jails are like a petri dish for the disease, right? And if the disease spreads or becomes, there's a significant outbreak in a jail, like I think you guys have it in your Calgary Correctional Detention Center.
Calgary Correctional Center. Yeah.
Well, that's making Calgary less safe. That's what the experts, the public health experts all of them will say very clearly that that is a danger to the entire community. So if you want to make the entire community safer, you want to reduce those prison populations to reduce the risk of outbreaks within those facilities, because ultimately it will get out. There's no way to stop that. It will get out into the wider community. So, sometimes that's another argument that can perhaps be used with people or authorities that may otherwise not be as sympathetic as they could be for the individuals who are incarcerated, if you know what I mean.
Yeah. Well, another question. I think we got a few minutes left in your time slot here. So, Madam Justice Arbour in the Royal Commission of Inquiry into the Kingston Prison for Women situation mentioned that where sentences are not being administered as they should be by law, she advocated a constitutional remedy, which would be a sentence reduction. And I think it would be under 24(1). So let's say we've got a prisoner who you've tried you tried the other remedy, the parole by exception. You've tried temporary absences, and this prisoner still is in a dangerous situation, and they aren't complying with the COVID-19 protocols. What do you think about that? Bringing an application for a sentence reduction under 24(1).
Well, we in the Snow case again, we did actually have charter relief in there as well. We did rely on Section 7 of the charter and Section 12 of the charter. We said that when he was sentenced, it never would have been contemplated that he was going to be imprisoned in a location where there's a communicable disease that was a high risk of taking his life, and particularly given the not very severe nature of his crime, we said that this was a disproportionate sentence in the circumstances, and that basically the circumstances had changed from when he had been sentenced. And further, that it shouldn't be a life sentence, right? That if he's at a high risk of death, then that also was a reason why he should be released. So we were kind of going in a double-barreled way. We were saying, hey, look at here's Section 116 in the Act. This is the statutory mechanism that can lead to release. But in any event, the charter overrides, and even if you feel he doesn't meet the technical criteria under the Act, on some aspects, the charter can bridge those gaps, shall we say. So, I mean, we never got to argue that. Could it, in the right case, be successful? I think it could. I think if you were if you had a very high risk situation where there was a current outbreak in a particular facility, provincial or federal, and you wanted to make an argument like that, I think I think there's an argument there to be made. And as we know, the case law around the charter and prisons are now much better than they used to be, thanks to the CCLA and the BCCLA.
So the two-pronged approach, you could call that, okay, here's the easy way, here's the hard way. And probably the guess that Canada looked at an alternate remedy and might have been afraid of that one too.
I think so, Tom. Your mic kind of cut out there a little bit. It was a little bit robot talk, but I think I agree with you.
All right, and final question. I don't want to put you on the spot. Hope I don't sound like a robot right now. But
good now.
Would there be precedents for this parole by exception application that you'd be able to share if you redacted personal information?
Yes, in fact, I've done that. Our materials with Derek Snow, Mr. Snow directed us to share it as widely as possible, which we have. And similarly, the parole by exception, that stuff I have redacted and I've shared with a couple of counsel already. So if anyone wants to reach out to me by email, I'm more than happy to share, our redacted submissions, to assist anyone who wants to go that route.
Okay, well, thanks a lot, Paul. Very informative. Abby, your turn.
Great, thanks. And I hope to be informative and much less useful, though, than Paul, who is litigating on behalf of individuals day in, day out. And I am thinking about individuals day in, day out, but I'm not in the courts. So what I'll do is I'll give an overview of our litigation that we and Tom are involved with, and some of the high-level trends in Canada about incarceration and COVID and solitary confinement that gave rise to those concerns, and what we hope to achieve. And then Tom, you can fill in any gaps or ask me the hard questions. CPLA is, of course, a co-applicant. So when COVID was starting to hit the news, this is back, in February, but really in March. One of the things that really struck me very early on was all the news about cruise ships, right? It feels like a long time ago, but some of the very early, very clear cases of rapid spread with significant health impacts on people came out of those cruise ships. There were Canadians on those cruise ships and people were desperate to get off. They were confined to their rooms, and COVID was seemingly, spreading despite the fact that they weren't seeing anybody and they were locked in their rooms. And I immediately thought of prisons because, a locked down cruise ship is still a cruise ship. People in prisons, very similar physical cells, actually, very small spaces, in health emergencies are frequently locked into their cells, very congregate, crowded living environments. And really very similar concerns, I thought, for the spread of COVID. So, we have just under 40,000 people behind bars in this country. And when we saw the impact that COVID was having on the people in those cruise ships, we were extremely concerned about how it would act once it got into a penitentiary environment. And before coming back to CCLA recently, I'd worked with Howard Sapers on Ontario's review of corrections. I worked in the minister's office, working on legislation on Ontario's provincial corrections, trying to reform it. So I know provincially much more in detail, what those jails look like, how old they are, how poor the built environment is. And how crowded they can get. I think federal institutions, definitely you're getting people who are double bunked, people who are in, congregate environments. Provincially, you're getting people who are triple, even quadruple bunked. You also have, ranges with bunk beds in them. But, people quadruple bunked in a cell that was built for one, perhaps two, right? So it can be extremely crowded environments in the provincial level. And the other core concern is the health status of people who are behind bars. It's a very, very health challenged population. In general, research says that prisoners are 10 to 15 years older in terms of their health status than what their age would suggest as compared to somebody who isn't incarcerated. 25% of federal prisoners are over the age of 50. It is an old population, and they tend to be quite sick, right? Higher prevalence of heart disease, asthma, other respiratory diseases, diabetes. So for this population in particular, sitting there in our jails and prisons, not only are they at greatly increased risk of contracting COVID. And we have seen since March how COVID has spread through both our provincial and our federal prisons, but also the health impacts on this population and the personal risks to them if they contract this disease are greatly magnified compared to the broader community outside of jails. So we were watching carefully. It felt like, watching a slow moving catastrophe in the early days. Like every week seemed interminable. And I just remember continually checking to see if there were updates on outbreaks in prisons, updates on numbers, what correctional services were doing. And I think, it might be useful to people to get a sense of what has happened, not only federally, but also in the different provinces. We touched on Ontario a bit, but there was a substantial drop in the number of people who are behind bars across the country. So StatsCan has put out a couple national surveys. The most recent one was just in October. So we had a 19% drop in the custodial population in Canada from mid-February to April, and it definitely has slowed down, right? We've got another 1% decrease from April to May. So it was really stacked at the beginning, but almost all of that decrease is in the provinces and territories, right? So all of the provinces and territories reported a decrease in the number of people in custody. I'm just looking at these numbers to make sure I got them right. So by May, the average count of adults in provincial territorial custody is down 28% for those on remand, 27% for those in sentenced custody. And I think actually the decrease in sentenced custody is significant. I think there are a lot of people who are on intermittent sentences who got temporary, permanent, essentially temporary absence passes. So I don't know how much of that decrease is accounted for by the intermittent sentences. Those are people who are only coming to jails on the weekends provincially. But it is still, it's a big decrease in sentenced populations. Newfoundland and Labrador, Nova Scotia were the most successful, greatest decreases, 40% and 39% respectively. And so looking at the provinces and territories, a lot was happening. A lot was happening, both in the bail front, pretrial front, as well as in the sentenced population. We just weren't seeing the same numbers federally. So CSC, Correctional Services of Canada, did not take similar steps to depopulate its institutions, or at least they weren't successful in, if they did take steps. So average counts federally fell from nearly 14,000 in March to, they fell a couple hundred by April, a decline of 2%. And that decline of 2% has sort of steadily continued to drip down. So right now, actually, CSE just filed their responding record. So they now say that as of September, there's been an 8% drop in the federal population since March, February. So that's something. What is the driving force behind that drop? That's, I mean, for me, that's the key question. Are we, The Office of the Correctional Investigator looked at the early 2% drops in federal incarcerated population and found that really it wasn't, proactive efforts, unusual releases. What was happening with people weren't being committed to federal penitentiaries anymore because trials had stopped, right? So people weren't being found guilty and sentenced to 2+ years. So there weren't very many people entering institutions. And in the meantime, people's statutory release dates were coming up. So we still had the slow trickle out of the institutions that we would normally have, and a really reduced number of people coming in. So that was the population reduction. And given that we haven't seen a significant increase, we've seen this, same maybe 2% a month about decrease, it would suggest to me that we just haven't seen a concerted, organized effort federally to try to make sure that everybody who is releasable, everybody who could be safely supervised in the community is being supervised in the community, to both mitigate the spread of COVID in the institution for those who can't be released, and then to better and more safely ensure the health and safety of the people who are supervised in the community. So we, along with CPLA, the HIV/AIDS Legal Clinic Ontario, initiated an application. We brought evidence of what we knew at the time. This application was initiated back in May, of the possibilities for release, the safety of community supervision, the provisions under the CCRA that could be used to release people, including unescorted temporary absences, parole by exception, as well as all of the evidence that we've talked about what are prisons like, risks of COVID in prisons, the primary recommendations of public health experts, which is physical distancing, which is simply not possible in an environment like a prison, health risks to inmates. And then we did try hard to get as much evidence as we could from prisoners themselves. Really a significant challenge, because especially in May, a lot of people are on lockdown. And we can talk about that a bit, right? In the absence of letting people out of prison, CSC has relied extensively on very, very, very restrictive lockdowns. So we're talking, days where people don't get out of the cell at all, that last for weeks, months sometimes. So under those circumstances, you are not having access to a telephone for the most part. You don't have access to the same programs and services and volunteers that used to come into the institution. Lawyers couldn't get in touch with their clients in many instances. And the recent report from Prisoner Legal Services, which is great, terrible, but a very timely, very powerful exposition of what conditions of confinement have looked like during COVID. They mentioned there were 2 weeks where they didn't hear from anybody in the institution with an active outbreak, because people were just locked in their cells with no access. So, we brought evidence, and there are several affidavits, and Derek Snow is in there in terms of evidence, affidavits from lawyers about what conditions looked like, what infection control measures were in place, and what prospects of early release people thought they had access to or had tried. And so we filed that in May, and we have a court date in January. So much less expeditious litigation timetable than we were hoping. We filed an interim motion during the summer to try to compel CSC to use the break between the first wave of COVID and the second wave of COVID to fully prepare for quick, expedited releases. We did things like ask that they be compelled to create lists of everybody with significant medical conditions, that they start finding and working with community organizations on housing options outside of the institution. That also that's our January date, right? So I feel like in this litigation, we've always been playing catch up to COVID, right? By the time we file, COVID has already run through several institutions, and then we file our interim motion, and then by the time we hear that, we are in the second wave, right? There are active outbreaks in our federal institutions right now. So we will see. For those of you who are working on federal cases, take a look at the responding record. I've posted it on CCLA's website. Under we have a page dedicated to the COVID prisons case. There's a lot of information in there about processes that they think are in place and directives that they think they've given. And apparently in June they had a directive about medical temporary absences in light of COVID. And I will say I haven't read it all. It's over 1,000 pages, but there may be things that are of use to the litigators out there. I did manage to pull a few numbers from the responding records. So we were talking about parole by exception, and I'm just going to scroll to, so they say they've granted 12 cases of parole by exception and 11 cases are pending. So I don't know how many of those are yours, Paul. It's not over 2. There we go. So Paul is accounted for a good percentage of all of the cases under parole by exception, which is just a stunningly low number of cases. And I think I'm purely speculating here, and I'd be interested in other people's thoughts, but I would imagine it speaks to barriers to access to counsel, access to knowledgeable counsel, as well as perhaps delays. If the parole board is actually hearing these cases within 2 weeks, but the delays are on the institutional side in completing the reports, and maybe that's why there aren't more cases sitting before the parole board. They also say that the total number of people released on medical UTA between March and September almost doubled compared to the releases in the same period in the last year, but they don't tell us. I wouldn't imagine they had too many unescorted temporary absences for medical purposes previously. And they conveniently don't give us the number in that particular instance. And then they also said that they've granted on average 50% more early discretionary releases, but that gets you 5 days before you were scheduled to be released anyways, right? That is not a meaningful early release in the context of COVID. So that's increased to 180 from 74 in the same month last year. That's their best increase. So these are the kinds of things that they are pointing to. I think these kind of stats show that we just are not having a robust response federally, and as a result, people are getting sick, and people have died, and I unfortunately think more people will before this is all over.
Okay, so Abby, the application for interim relief has been set for January. Now, am I right? We do not have a date for the final hearing.
No, as far as I know, the only thing I know about is the January date. And I haven't talked to the other co-applicants, but given that our interim relief motion was targeting measures that should be taken to prepare for the second wave, anyways, I think now that we have the responding record, we're going to have to figure out, and given that COVID is researched as we knew it would, we're going to have to figure out, what the next steps, what makes sense in terms of the litigation. Because there's also new evidence about COVID, right? So now I think federally we've quietly updated our guidelines to say it is airborne. It's not just droplets, and that air circulation does matter. And that's a big deal in prisons. That's a really big deal in prisons. So that's not in our original application either.
So in our original application, I don't have it in front of me, but do you recall what the relief was that we were requesting?
Yeah. So we requested a mandamus order, and I can talk about the provisions of the CCRA that we're relying on if people are interested. But we requested a mandamus order, or if that fails, remedies under the charter. And there were a number of specific things we're asking. Proactive, systematic steps to reduce the population of prisoners in CSE institutions to the greatest extent possible, consistent with public safety. Ensure prisoners who remain in the institutions are not detained in segregation or segregation-like conditions, which I think obviously is what this week is focused on and is becoming an increasingly pressing problem. Implement adequate physical distancing for prisoners and staff, comprehensive COVID testing, contact tracing and isolation, adequate PPE supplies, hand soap, sanitizer, enhanced cleaning of common areas. But really for us, the focus was, you can only do so much with cleaning and sanitizing and PPE. Ultimately, if you have a lot of people living in close quarters, there are people who are going to get sick. So really the focus for us was on depopulation and trying to ensure that CSE was doing as much as it possibly could on that front.
And did we ask for a declaration?
I assume so. It's not in my notes, and it's been a while since I looked at the original. I'm sure we did. A declaration of that charter rights are breached, but I think it, in this context, I guess this is why I haven't focused on it. Sometimes I think declarations are incredibly powerful. With a fast-moving pandemic, I want them to do something, and so,
Right. So what I'm thinking about is by the time we have the final hearing, it may be the pandemic is over, and of course, then the government will resort to its favorite argument: it's moot.
Right.
So, just a tip for people who want to avoid that and to get a meaningful precedent: always plead for a declaration, because they won't be able to moot you out if you've asked for a declaration, at least in my humble opinion. Okay.
Well, let's hope that.
All right. Now,
sorry, I was just gonna say, let's hope we don't. Let's hope that the litigation runs faster than COVID. I still hope that we will be able to get in front of the court in time to do some good. And part of this is part of litigation. Part of my thoughts about why litigation is useful is not always about the end decision. The process of bringing the claim, talking about the claim, asking questions, calling out answers, and disclosing information through the litigation process, I think, is also valuable to try and provoke change.
Okay, let's shift gears here. I want to spend some time with the panelists on what amounts to solitary confinement in terms of the CSD's response to COVID-19 threats, outbreaks, and we know that this is happening across the country in all provincial jails, all territorial jails. This is solitary confinement plus. It's terrible, the conditions that some prisoners have to live in as a result of the response that the government, the prison authority. So look at it this way, and let you get some comments. If you are in certain type of conditions of imprisonment, and then they stick you solitary confinement, what is your right to apply for habeas corpus, right? So then, and also, I favor bringing a habeas corpus along with a 24-1 application. So if you don't get the release, like you wouldn't want to necessarily get released from solitary confinement conditions and be put in a dangerous situation COVID-19 wise in the prison. So I look at 24-1 as possibly providing a a remedy that the prison authorities have to release you anyway because of the danger to the prisoner, or at least they have to change the conditions you're being confined in. For example, no 4 people in a cell, 1 person, or they have to mitigate these oppressive conditions. They have to give prisoners something meaningful to do. They have, and I know we're asking for that sort of thing too in the federal court action we filed, but prisoners need immediate relief. So I'm wondering what you both of you think. I'll start with Paul. What you think about bringing such applications, and for remand prisoners, they have lawyers, and my view is it's the duty of the lawyer defending the client to bring that application. Sometimes it'll require you apply for extra legal aid coverage. Sometimes you get it, sometimes you don't. I think you have to bring it anyway. So, and you could bring it in conjunction with a 525 review under the criminal code, where the case law says you can take into account prison conditions. So what are your thoughts on that, Paul? It's I've thrown a lot out there, but any comments?
I think if you've got the right sympathetic case or the right sympathetic facts, you might have a shot. I mean, as you all know, the courts are very reluctant to interfere with what correctional authorities are doing. Post sentence, once the individual is sentenced, they try to be very hands off, and the idea that they're going to be releasing people without any particular statutory provision, I think would be a real hard reach for a lot of judges. But at the same time, I think if you have the right sympathetic case, I think you could get it. I think you could frame it that way. Again, I mean, like Derek Snow was in many ways a very perfect case. I think that's why the government and the Correctional Services Canada moved so quickly to get him out. He had no violent offenses ever. He had a very, very long criminal record, but it was all related to property offenses to feed his drug habit. Whenever he was caught, he would admittedly just, you'd always just turn himself in and so forth. And then his health circumstances were very dire. And the man was in a wheelchair at that point, and had only been for a couple of months. So, in those facts, I mean, the government looked terrifically callous. That didn't stop them until they thought it was going to be exposed to a judge. And in fairness to the court, I mean, the court understood how serious it was. The government was really trying to kick that case down the road, like several weeks or months even. They said, oh, we don't have enough time. But because the facts were so compelling, the judge just said, no way, we're going to have that, that hearing next Thursday. So, I mean, all of that was really helpful. But I don't know, Tom, I think if you got the right facts and your client's background isn't too egregious, then, good facts make good law, right?
And I think that that if you go under 24(1), you could craft a remedy which would be akin to house arrest, a conditional sentence, reporting to a probation officer or parole officer, all those things, even an ankle monitoring bracelet. I mean, 24(1) gives a judge a wide discretion in terms of a suitable remedy. Anyway, I tried that in one case, and I got my guy out on bail, and so I never had to proceed with the 24(1). But if anybody would like to see that precedent application, I'd be glad to share it too.
I think it's a little, yeah. Go ahead, Debbie.
I've done some thinking about habeas and bail, because we were also trying to pay attention to the provincial population, most of whom are in pretrial. And I do think it gets a little more complicated when someone is pretrial, because as far as I can tell, and I'd be happy to be wrong, the access to habeas is not as broad, right, as sentenced. Most of the time, the answer is you should go for a bail review. Right, if things have changed and COVID is a material change in circumstances, and if conditions have changed, you should be applying for a bail review and show us, how the bail regime is unconstitutional, and then we'll maybe give you a kick at the can through habeas. And couple that with a lot of the provincial bail regimes getting a lot more people out, which I think they should have been doing in the first place without a pandemic. But it was just it was harder to figure out how to successfully craft a habeas claim for the pretrial population. But certainly for the sentenced provincial population, the considerations would be very similar.
I think that, for a remand prisoner, what you're seeking usually would be by habeas. Yes, you go bail, you go 525 review. If that doesn't work, then you can go habeas to have them released from solitary confinement, administrative segregation, and back into the general population. And if they can't do that because of the COVID lockdown, then I think that the judge might be inclined to just release. But that's where you might resort to 24/1. Anyways, it's an interesting analysis, and I hope I have to try it someday. Okay, Paul, you were going to say something more.
No, nothing. I was just going to say the stars would have to be aligned. I think a little bit to have the right judge rely on 24/1 to override a statutory provision. I think would be very tricky. You might even make an argument that the statutory provision is not capacious enough. Actually, like even the unescorted temporary absence provision, section 116 for federal prisoners, you actually have to serve a certain amount of your sentence. I think it's 1/3 of your sentence before you can even qualify. So we had in one of my other cases, I was getting ready to argue that the statutory provision, there was a breach of the charter, because if you're being released for medical reasons on an unescorted temporary absence, it really shouldn't matter how short or long you've been in jail. So I was going to attack that one provision or one aspect of the provision. So I think, it's better to try to, my view anyway, to try to parallel or pair it with some statutory provision that could otherwise get your client out. And if there's one small sub provision or paragraph that is an obstacle, you say that particular provision is violative of the charter in these circumstances. But it's it requires a lot of creativity for us, for sure.
Okay. Anything else from you, Abby?
Just that, the U.S. has been doing a lot of interesting litigation down there on prisons and depopulation and COVID. And one of the things, very similar to what Paul was pointing out, one of the things that the courts in California, I think, recently looked at was the restrictions on who could be proactively released, and that your index offense couldn't be a violent one, right? Which of course does not correlate to whether you can be safely supervised in the community. There are lots of people who are convicted of violent crimes who present very, very, very minimal risks to public safety. So those kinds of ultimately arbitrary distinctions and impediments to release, I think, are ripe for challenge.
Yeah, I was just looking on my phone here. I subscribe to a listserv. It's on solitary confinement. It's called Stop Solitary. I don't know if you've ever heard of that, but it's basically U.S. law on solitary confinement, and that's why I read about the case you were talking about. It's a pretty good list for that, and it because American law in a lot of ways is way ahead of Canadian law in many ways. So All right, I guess it's time to wrap it up. And I want to thank Paul, Abby, for participating in this, the Health Law Institute, the Canadian Elizabeth Fry Society for facilitating this. And I think you can see from our discussion, there are a lot of prison lawyers out there in Canada who it's a small community, but it's a very active community, and we're all willing to help. So if you want to get some help from any of us in the CPLA, CCLA, and the other organizations, all you have to do is ask. So with that, we'll say goodbye.
Thanks very
Thanks,
much, Tom.
Tom.